Hello, everyone. Thank you so much for joining us. We'll go ahead and get started. Um, Today is the final part of our Fair Housing and Tenant Rights Training series. And today we're focused on the eviction process overview. And we're presenting today with the Bay Area Legal Aid. And our presenters, we have our Anna, Allison, and Darlene from Bay Area Legal Aid with us today. And just to introduce myself quickly, my name is Sadaka. I am a policy analyst here at Homebase. Homebase is a nonprofit technical assistance provider. We provide TA for COCs across the nation. We work closely with the Office of Supportive Housing in Santa Clara County. And one of the many things we do is put on trainings on behalf of the Office of Supportive Housing, including this Fair Housing and Tenant Rights Training Series. And then as you see today, this training is going to be on the eviction and protection overview. The Bay Area Legal Aid will give you an overview of the services that they provide, and then we'll go into the subtopics. And just to let you know too, today's training will be recorded. After the training, you will get an email with the slide deck and then posted on the CoC SPN listserv. We will let you know when the recordings for all three parts of this training is available. And then in terms of training housekeeping, I know all of you are familiar with Zoom by now, but we do want to just let you all know that we're going to keep everyone on mute by default, but there will be questions at the end for you to unmute yourself. In the meantime, please use the questions. Please put your questions in the chat. Folks from Bay Area Legal Aid will be able to answer some of your questions. And if you have any tech issues, please chat me directly so I can help you. And if you get kicked out of Zoom completely or otherwise unable to use the chat feature, you can email at santaclaracoc@homebasecc.org. And also closed captions are available. So if you hit closed captioning, you should be able to see them. And I'm going to pass it to Allison, Anna, and Darlene soon. To get you all started, I'm just going to switch over slides.
And maybe while we're switching over slides, we can just introduce ourselves. Good morning, everybody. My name is Allison, and I'm a staff attorney with our housing team in the Santa Clara office.
My name is Anna. I am also a staff attorney in our Santa Clara office.
Good morning, everyone. I'm Darlene. I'm also a staff attorney for housing in our Santa Clara office. It's great to have you all here today.
Awesome. And I see the slides are up, so we're ready to go. Today we'll be talking about the eviction process. And we do have quite a full day today. Next slide, please. So I'll just briefly talk about our scope of services and eligibility for folks who have joined the previous two trainings. I know you'll be familiar with that already. And then we'll jump into kind of the bulk of our training today, which is covering the eviction process. We'll cover kind of start to end, everything from eviction notices, understanding a summons and complaint, how to fill out an answer, preparing for trial, negotiating a settlement, and then what happens after a judgment. Next slide, please. Great. So, so again, for folks who've seen the other two trainings, this might be a bit repetitive, but just as a reminder, Bay Area Legal Aid is a regional firm. So we have offices all over the Bay Area. We are part of the housing team here in Santa Clara County, but all of our offices have different practice areas, and we, in our housing team, cover primarily the housing preservation and homeless prevention matters. So that includes assisting clients in addressing landlord-tenant matters, defending against illegal evictions, asserting rights under fair housing laws, combating discriminatory housing practices, We also assist clients with subsidized housing issues, including helping them preserve their Section 8 vouchers or tax credit units. We also have an immigration unit that works pretty closely with our family law office, and the scope of those services are listed as well. We have our health consumer clinic, which assists clients with navigating services from public and private health insurance programs like Medi-Cal, Medicare, other county health programs. And then we've got our family law unit, helps primarily with domestic violence and sexual assault prevention. And we also have our economic justice and consumer law project, as well as a youth justice project. Next slide, please. So to be a Bay Area legal aid client, you do need to live in one of the counties that we serve. And you also need to be a citizen or eligible immigrant. That includes US citizens or folks who have family members who are citizens with a pending application for permanent residency, permanent residents, refugees, asylees, and so on. In general, you do need to have a gross income that's under 200% of the federal poverty line, but we do have an exception for our health work. And yeah, next slide, please. And so this is how to access our services. In general, all practice areas should call the legal advice line. The hours are start at 9:30 and they go until 1 o'clock or until capacity is reached. So we do encourage folks to call right at 9:30, and folks can leave a voicemail and receive a call back in 24 hours. Or if someone wants legal advice on a health consumer issue, we have a specific line for that as well. And so now I'll hand it off to Darlene to start talking about the eviction process overview.
Thanks, Allison. Yeah, we'll spend some time to get started this morning regarding eviction process and get a general understanding of the whole process of an eviction case and get into the more minute details later on in the presentation. Next slide. This graphic is a high-level overview of the basics of an eviction process. I think this is really important for tenants to know. Starting at the top with a written notice terminating the tenancy, a lot of tenants will, we hear a lot from our clients as far as, stories about people get a notice on their door posted regarding, a 3-day notice or whatnot, terminating the tenancy for either non-payment of rent or another reason. And, the feedback we hear is that, oh, I guess I'm evicted. And then they feel that the process is started and over. But no, there's a lot of other steps that go into this. So, first and foremost is receiving the written notice terminating the tenancy. Given the opportunity, for a 3-day notice to pay or quit in a lot of our most frequent cases. And then ultimately, if payment isn't made within that duration, then the landlord will proceed with an unlawful detainer action where the landlord has filed a lawsuit in court. And then the legal process begins for an eviction. The next step is that the landlord would serve a complaint on the tenant. This is generally done through personal service, but service can be affected through substitute service, through another adult that lives within the unit, or if there is an application to serve a tenant through posting and mailing, if they have made good faith efforts to personally serve the tenant and are unable to do so, there's a process for landlords to file to effect service a different way. And so it's important for tenants to know that there are a variety of ways. But generally it will be someone knocking on the door and providing a summons complaint to the tenant personally, and then a proof of service is filed with the court. The law has changed this year. The tenant now has 10 days to respond, which is a fantastic improvement in the law to give tenants the ability to respond in court with an answer to the summons and complaint, or with some other legal response to the action. Generally, after the answer is filed, the landlord will request a trial date. And so there will be a request to set case for trial. And that this will be done, at the landlord's initiative. Some attorneys out there that do this work frequently are like clockwork with this. And so once that answer is filed, they're watching for it, and the request for trial date gets set. Other landlords may take a bit of time to get that done. So it's important to keep an eye on the mail in terms of seeing that notice, and then also getting a letter from Superior Court showing that a trial court date is set. And this is generally done within 20 days after the landlord requests that the case be set. But this, and sometimes our clients, that letter from Superior Court, when service has not been done properly, is sometimes the first they learn about the action. So they might get a letter from Superior Court with the date and time that they need to appear in court. And then that's, their notice of the court date. Again, it's important to know, for tenants to know that this is a process, really at the time that they're leasing up, is, that, life skill information as far as, in the event something goes wrong, in the event you're not able to pay your rent and eviction, or notice is, posted on your door. This is an eviction process, and use the times that are available under the law to protect your rights as a tenant. Okay, next slide. And again, the legal process for an unlawful detainer or an eviction case is the lawful manner for evicting a client. Self-help evictions by a landlord are illegal. Self-help evictions show up in different ways. They could be landlord changing the locks or blocking a tenant to get access to their home as a way of trying to terminate the tenancy. This is illegal. Landlords cannot shut off utilities with the intent of terminating the tenancy. We see this, landlords are turning off water, landlords are turning off heat. That is illegal. And landlords may be liable for both civil and criminal penalties if they carry out a self-help eviction. So again, the process is what we discussed on the first slide, and it starts with a notice and then followed with an unlawful detainer case. Okay, next slide. This is a flow chart and an overview of the eviction process. Starting at the top, a tenant would receive a notice. Let's just say, for simplicity, say notice to pay rent or quit, with a 3-day notice, 15-day, 30-day, 60-day, 90-day. The law requires different days depending on the tenancy. For those clients that are voucher holders, there are additional protections involved. And so it's important to be able to see what the law provides for individual tenants to see whether a notice is valid. Assuming the notice is valid, and let's say the tenant, does not pay the rent within the prescribed legal period, then the landlord will follow with a summons and complaint. And again, the tenant has 10 days to file a response. So following the flow chart, if tenant files an answer or response, then the landlord will request to set the case for trial. Again, the tenant will receive a notice of the trial in the mail, and the trial date will be set in about 20 days. It's a very quick process, and so it goes very, very quickly. And then in terms of the day of trial, and we'll talk about more details regarding what happens on trial day. The trial goes either way. There's either a judgment for the tenant, given the tenant to pay the opportunity to pay the back rent and gets to retain their tenancy and stay housed, or there's a judgment for the landlord. Now, going back to the top of the chart with a summons and complaint, if the tenant does nothing and does not file an answer or response to the summons and complaint, then the case can proceed by default. And so after the expiration of that 10 business days, the landlord will request that the default be entered. The court will process that default judgment. And then the next, generally the next step that the client will be aware of is that there will be a posting on their door from the sheriff's department with a lockout date and time that they will return to do a sheriff's lockout. At that point, after the lockout notice is provided, the tenant can request a stay from the court, generally up to 40 days, but the tenant has to pay for that upfront at the courthouse. And so they do have an opportunity to, maintain their housing so they can, arrange for time to move properly, as opposed to the sheriff's coming to the door on the day of the lockout and having, less than a half hour to collect a few things and go. And if that stay is not requested, then the lockout will generally happen. Sometimes the sheriff's office does get backed up, and so they may come after the date. But then the lockout occurs, which is not ideal, certainly. Okay, next slide, please. Okay, we have a poll to get started this morning. Have you ever helped a client complete an answer in response to an eviction filing, which is an unlawful detainer complaint? Yes or no? We just want to get an idea of, what assistance our clients have out there, and want to hear back from you. Okay, so answers are coming in mostly no. Okay, great. Give an opportunity for a few more of you to respond. Okay, let's go ahead and share the results. Okay, 78% no, 22% yes. Okay, great. Next slide. Okay, and as you see with the clients that you work with, there's in the eviction process, there's legal basis for eviction. Landlords in California can begin the eviction process for several reasons. And, as we discussed before, most frequently what we see is a non-payment of rent. There could be a legal basis for eviction for a violation of a lease or term of the rental agreement. They could be a tenant at will, which means there's no lease, there's an end of the lease term. There could be a foreclosure on the rental property. Unfortunately, there could be criminal or illegal activity that has occurred on the premises, which has led to a notice. And a variety of other reasons. Local ordinances such as the San Jose Tenant Protection, as well as the state's Tenant Protection Act, which is also known as AB 1482, do provide additional protections to tenants. Next slide, please. We'll spend some time this morning talking about the types of notices. And again, this starts with a notice posted on the tenant's door that would give the type of notice that they receive. 3-day notices are very common. We see a 3-day notice to pay or quit, and that is when a tenant is behind on rent. And so basically the notice is saying you have 3 days to pay or quit, meaning leave the premises. A 3-day notice to cure. And this is when the landlord is alleging that the tenant has breached the lease, but that the problem is able to be fixed. And so you might see this with, perhaps noise disturbance. Let's say, there's, noise activity after quiet hours according to the lease. And the landlord may give the tenant the opportunity to say, look, you've violated the lease in regards to the quiet hours for the unit in the property. And you know, that needs to stop and in order for you to maintain your tenancy with us. And then there's also a 3-day notice to quit when the landlord believes a tenant has breached a lease in a way that can't be fixed. And we often see this in regards to any engagement in criminal activity that may have occurred on the premises. And so basically the landlord is saying they're within the right just to terminate. There's not a chance to fix it because what has happened and cannot, you know, cannot be fixed. And so they've provided the notice based on that. Within 30-day, 60-day notices for all month-to-month tenants, landlords are required to give lease termination notices before evicting them. In California, landlords must either give 30 or 60 days notice, depending on how long the month-to-month tenant has lived in the unit. So less than 1 year, the landlord must provide the tenant with a 30-day notice to quit. 1 year or more is a 60-day notice to quit. And a 90-day notice, as I discussed before, is required for rental property foreclosures, and then also all tenants with a Section 8 voucher to provide that additional protection for our Section 8 clients. And I just wanted to take a time out before going to the next slide, is that you know, starting at the top with these 3-day notices, that is where a tenant, you know, has really to be empowered to be able to, especially in non-payment cases, to resolve the case. And so having that payment come in before the expiration of that notice is critical. And I know many of you on this call do this work daily and are preventing hundreds and hundreds of evictions from being filed because you're doing this important work and heavy lifting. And so I just wanted to say thank you, you know, because you're preventing cases from being filed for eviction and preserving tenancies and preventing homelessness each and every day. And we're so very thankful. And, you know, the community partners that we have in Santa Clara County are outstanding. So I would be amiss to not, you know, applaud the efforts that you're taking every single day to preserve tenants' housing within our communities. So thank you so much. And with that said, we're going to go to the next slide. And I'm going to turn things over to Allison regarding just cause protections.
Thank you, Darlene. So I also talked about just cause protections in our first training of this series. So some of this might be familiar, but we will talk about it here specifically in context of the eviction process and the protections that apply. Most tenancies in California these days are covered by just cause protections under the California Tenant Protection Act. And so I'm going to just briefly talk about those just cause protections. And I think the slides have disappeared, but oh, they're back. Okay, great. Next slide, please. Thank you. So this is the California Tenant Protection Act. It protects tenants in a couple critical ways. First, in a covered property, once a tenant has been in place for 12 months or longer, the landlord can only evict that tenant for specific reasons, and those reasons are called just causes. Also, in a covered property, landlords cannot raise the rent more than 10% in any 12-month period. And so a covered property is going to include a property where a tenant has lived there 12 months or longer, or if there's other tenants who are added, then in that case, then just cause applies when all the tenants have lived there for 12 months or one or more of the tenants have continuously lived there for 24 months. And there are two types of just causes. They are categorized as at fault and no fault just causes. Unfortunately, not all properties are covered under the California Tenant Protection Act. There are some exemptions listed in the code, and that is going to include housing that's restricted by deed, or a covenant, which would include like low-income housing tax credit properties, those LIHTC properties. They're not covered under Tenant Protection Act, as well as dorms. And there's a few other important exceptions. I won't get into that here, but if you do have questions about the other exemptions, please feel free to put a question in the chat. Next slide, please. So these are the listed out just cause reasons for termination. The no fault just causes are on the left side of the screen, and the at fault just causes are listed on the right side of the screen. No fault just cause, those left side reasons, those are going to require a 30 or 60-day notice. And those reasons are listed here. So these are things that a landlord can terminate a tenancy for, but it's due to no fault of the tenant. So as you can see, that would include withdrawal of the residential real property from the rental market, so not wanting to rent at all anymore. If the owner is complying with an order from a court to vacate regarding habitability, so if the building has been coded as uninhabitable, then folks can't live there anymore. Or if the owner intends to demolish or substantially remodel the property, that would be a no fault just cause reason. And then another common one is if an owner wants to move in, or if the owner wants their family to move in, then that could be a reason that the landlord does not want to rent to their tenant anymore. The at fault just cause reasons, those are on the right side of the screen, like I said, and those are things that allegedly the tenant has done something wrong, and now the landlord is hoping to evict the tenant for that reason. Those kinds of reasons, the at fault, those only require a 30-day notice. Or I'm sorry, a 3-day notice. So 3 days is a lot shorter than 30 days. And then those reasons are not paying rent. So if the tenant doesn't pay rent, they can get a 3-day notice to pay or quit. Or if the landlord alleges that the tenant has violated the lease in some way, if there's a nuisance of some kind at the property, waste, refusal to enter into a similar lease agreement, criminal activity, assigning or subletting when that's not allowed in the lease, refusing to allow the owner to enter the premises, using the premises for unlawful purposes, and if a tenant is an employee and their employment is terminated and they refuse to vacate, that's a reason. And then failure to vacate after a tenant actually provides notice would be an at-fault reason as well. And so, yeah, these are the core at-fault and no-fault just cause reasons for termination. As of April 2024, there's some strengthened protections specifically for those no-fault reasons. So let's talk about those on the next slide, please. Thank you. So with the passage of Senate Bill 567, the Tenant Protection Act was strengthened to require documentation for some no-fault reasons. And it was also strengthened to include an enforcement provision. So previously, there was no statutory requirement for a landlord to substantiate its no-fault reasons at that initial notice stage that Darlene had talked about. As of April 2024, landlords now have to provide documentation for 2 of the main types of those no-fault notices given to tenants. The first is owner move-in. So the notice that the landlord gives the tenant needs to include the name of the family members who plan to move in. And then if there's substantial remodel or demolishment happening, then the landlord needs to provide copy of permits or contracts of the work that's going to be done at the property. So those are the additional protections required at the notice stage. There's also an enforcement action that was created here. So if a housing provider is violating the Tenant Protection Act, then state and local law enforcement can bring enforcement actions now. For the rent cap provisions, if those are violated, then the provider can be liable to the tenant. And some of that liability might look like actual damages, attorney's fees, and that can be multiplied by 3 if the owner acted willfully or with fraud, malice, or oppression. Okay, next slide, please. Okay, and here in San Jose, for residents of San Jose in older apartment complexes, then there are also local just cause protections that are even better than the statewide just cause protections. This applies to buildings that have a certificate of occupancy from before September 1979. The Tenant Protection Ordinance went into effect in 2017, and it applies similarly to all covered units. So if the Tenant Protection Ordinance applies, then all terminations of tenancy must be based on one of the 13 just cause reasons that are listed in the San Jose Municipal Code. And it's a similar list of reasons, but a little bit different. Additionally, relocation benefits must be paid when a tenant is being removed from an apartment for a no-fault just cause reason. And the landlord has to also provide tenants a right to return in certain circumstances. So covered units do include rent stabilized units, rent units in multiple dwellings, except for hotels and motels, guest rooms, and unpermitted units. Next slide, please. Okay, so we do have a hypo here. Teresa lives in an apartment complex and has been there for 1.5 years. Teresa's landlord told her that he intends to substantially remodel the unit. The landlord serves a 3-day notice to quit. Can her landlord evict her based on this notice? Great. So seeing a lot of responses come in. Okay, great. I think we can wrap the poll up. And we can share the results. So yes, people are right. The answer is no. If covered under the Tenant Protection Act, then a 3-day notice to quit is not proper. It's not enough time. So a 60-day notice would be required in this instance. Okay, next slide, please. Okay, this one's a little bit trickier. So it's also a hypo. Teresa has a Section 8 voucher. She moved into the unit on July 1st, 2018. Teresa's lease expired on June 30th, 2019, but her landlord continued to accept her rent. On July 31st, 2022, Larry landlord issued a 30-day no-cause notice to terminate her tenancy. So is this a valid notice that Larry landlord issued to Teresa? And it's a little bit tricky, but do the best that you can. And it looks pretty split so far from the results. We can go ahead and wrap the poll up and end it and share results, please. Great, so whenever the results are ready to be shared, we are ready. But the answer is false. And we're going to talk about why on the next slide. So next slide, please. Thank you. So we've got the same facts. There's another hypo here. So let's just think about it a little bit more. So same facts. We've got a 30-day no cause notice. So we know that the previous notice was not valid. In this hypo, how much notice should Teresa have received? I'm not seeing the hypo come up, but oh, there it is. Thank you. So how much notice should she have received? Keeping in mind there might be protections for people who have vouchers. Okay, and then the second question is, if she does not have a Section 8 voucher, then how much notice should she have received with no voucher? Okay, so I think we can end the poll and talk about it. So for number one, Teresa should have received a 90-day notice because she's a Section 8 voucher holder, and her tenancy was ended for a no-fault termination reason. So she should have been given 90 days. For number two, if Teresa did not have a voucher, then she should have received a 60-day notice because she's lived at the unit for more than a year. And this is still a no-fault termination reason. So yeah, so I think we did very well on that. Okay. That is the end of the just cause protection. So I will now hand off the next section to Anna.
Thanks, Allison. All right, I'm gonna do sort of the most boring part of this presentation. It's a very technical, step-by-step review of what a tenant should do when they get an unlawful detainer summons and complaint, and yeah, how to file their response. Next slide. So we've sort of broken it down into 7 steps. I mean, 6 steps really for filing your response. Step 1, figure out when the tenant actually needs to file their response by. Step 2, review the summons itself. Step 3, review the notice. Step 4, complete the answer, and in most cases, for people that we're working with, the request for a fee waiver. Step 5, get a friend or family member to serve your answer. And step 6, actually file with the court. Next step, or next slide rather. Okay. So figuring out your deadline to file. First, the tenant has to have gotten the court papers. If the tenant is not sure, if there's they're like, I think there might be a case against me, but I never got served, they can ask the landlord directly, is there a case? Or they can go to the courthouse or call the courthouse and say, like, is there a case with my name on it about this property? What's supposed to happen is the tenant should be personally handed a packet of anywhere from 10 to 60 pages, usually depending on how long the lease agreement is. The first page would say like civil complaint cover sheet, and then the second page would say summons. And in the top right page of the summons complaint, it'll have the case number and a little stamp by the court clerk. In this year, 2025, that number for the court case will start with 25 CV and then a bunch of other numbers. All right, and it is also permissible in certain circumstances for a tenant to be served by posting and mailing, so not personal service. So the tenant should not assume that posting and mailing is invalid. Sometimes it is invalid, but it's fact specific. So if you don't have access to a lawyer, just assume that you have to respond in the standard timeline, no matter how the tenant received the service. The basic standard timeline to respond is 10 court days from whenever the tenant got those documents. How do you count those days? The day you got it is day 0, and then you count to 10. The last day is, the 10th day is your day to file, last day to file. As Darlene mentioned at the beginning, this 10-day timeline does not count weekends, and it doesn't count court holidays. You can look up your court holidays at the court website. We got a link here just for funsies. Next slide. Poll question. If you have a client who tells you that they were personally handed an unlawful detainer summons and complaint today, Wednesday, April 16th, when is the last day that they can file their answer or response before they risk losing by default? Got about 30 people answering, so I'm going to wait a little longer because there are over 100 of you here, which is great. All right, I'll close the poll now. Most of you got this right. There's some variation. The correct answer is Wednesday, April 30th. If you look at this little calendar here, right, you can look at the number 16, 17, and we just count the business days. There are no court holidays in that interim, so 17, 18 are days 1 and 2. 3, 4, 5, 6, 7, 8, 9, 10 takes us to 30. So we skip the Saturdays and Sundays. That was not very helpful, I realized, because you can't see like little my mouse on the little calendar, but it's fine. Next slide. Yeah. Step 2, you figured out your last day to file. We're pretending it's April 30th for the purposes of today. Now you assist the tenant with reviewing their paperwork. The most important information to get from it at the outset is to look for the case number, which is in this. If you look at this sort of image here of this document page, there's the white box on the top right corner. That's where the case number will be. The court address and the court name will be on here somewhere, although honestly, I'm not sure where it is on here. And then at the very bottom of the page, in tiny font, you'll have the plaintiff or the plaintiff's name or the plaintiff's attorney and their contact information, which is very important because if the tenant wants to try to negotiate a settlement agreement before court or even at court, they're going to be negotiating with the lawyer. And so they'll want to know how to reach them. Next slide. Step 3, review the notice. So Darlene and Allison talked a lot about the notices that are fundamental to an unlawful detainer lawsuit. Every eviction lawsuit, every summons and complaint should have in that packet somewhere the notice that they claim to base the lawsuit on. It's usually Exhibit B or Exhibit 2 or something. So you can find it in there. Sometimes it takes some searching. If the notice doesn't comply with one of these many rather complicated notice laws, then the lawsuit is defective in a huge way. So the tenant should start by reviewing the notice, making sure that it was a notice they were actually served, making sure that it's the same notice that they got, like it's an accurate copy. Check to see if it's asking for rent or if it's saying there's some other violation. Check to see if the notice cites to any specific laws. Those can be, the tenant can look at those, the language of the law to say, I didn't violate, and that's the wrong law or something like that. And in San Jose, the notice is always required to include information about tenants' rights or an attachment with San Jose's tenants' rights resource, some of tenants' rights resources. Yeah. There's also like a state law that applies only in no fault notices about tenants' rights to like reclaim their property, but we don't need to get into that. Since most people are encountering notices to quit or to pay or quit or something like that, it's not really relevant. The reason we're emphasizing notice defects in this training is because a notice defect, right? The laws are straightforward, right? The law says notice includes X, Y, Z, right? And then the notice is provided to the tenant in the lawsuit, right? So they have the evidence there. And all they have to do is say to the judge, here's the law, here's the notice, they don't match. And the judge doesn't have to be very tenant friendly to say, oh, you're right, we'll dismiss. So that's why we focus on that. And then if the landlord is really committed to trying to evict the tenant, they have to issue a whole new notice that is, complies with all laws, and then file a whole new lawsuit. So it gives the tenant a lot of time and leverage. Next slide. All right, step 4, completing the actual answer form. This slide is just about the answer. The tenant, this can take, some time. So give yourself at least an hour, or you and the tenant an hour to review it all together. Make sure you have the summons and complaint with you because you're going to need to refer to it. Bay Legal has an answer guide that explains the affirmative defenses in a lot of detail.
I saw the thing. I bet.
Explains the affirmative defenses in a lot of detail. It's always best to check. So we used to have like a photo of this form on the slide, but it's like not that helpful. But anyway, so the answer form is a 4-page form, and most of it is a list of potential affirmative defenses. These are things that the tenant can say, where the tenant says, even if everything the landlord says in their complaint is true, I should still win because X, right? Tenants should be over-inclusive in checking affirmative defenses. There's no black mark for marking something that turns out not to be that relevant. But if you forget to mark something that is relevant, potentially the judge will prevent you from arguing that defense at your trial. So definitely be over-inclusive. Anyone named as a defendant must file an answer. If your name is spelled wrong, you still have to file an answer. If they give you an AKA that you think is ridiculous, you still have to file an answer. All the defendants can just sign one answer and file that together. But if, say, you have different defenses, say there's, roommates that don't have any special relationship to each other, it's best to file your own answer each tenant should file their own answer, because if you all file the same answer, you're all agreeing to assert the same defenses at trial. When the tenant is done filling out the answer, they should make 3 copies. 1 copy to file with the court, 1 copy just to hold on to, and 1 copy to mail for service, which we'll get into, to mail to the other side, which we'll get to in a couple of slides. Next slide. When a tenant is filling out their answer, you have to write your name into the form exactly as it is written on the landlord's summons and complaint. Even if they spell your name wrong, the clerk will not accept your filing. The court clerk will not accept the filing if you try to correct your name spelling. So you gotta just use what they've given you. Paragraph 2 of the answer form is this section with a box for general denials and specific denials. General denial is a box that the tenant can check only if the lawsuit is asking for less than $1,000. In Santa Clara County, that is very rarely the case when there's rent demanded at all. But yeah, anyway, I would try to do specific denials if you're not sure. When the lawsuit demands more than $1,000, then the tenant is supposed to go through each section, each paragraph of the landlord's complaint. It'll be numbered 1, 2, 3, 4, 5, or sometimes some of the firms in the area like to use Roman numerals, but whatever, it's the same thing. You say I deny paragraph 1, I deny paragraph 2, I deny paragraph 6. If the tenant isn't sure what to say here, or just gets overwhelmed, it is far and away best practice to say, I deny each paragraph of the complaint. Just say, I deny it all. Because if you admit or forget to deny a section of the landlord's complaint, then the court will treat it as though it is true at trial. So the landlord won't have to prove their case on that issue. Next slide. We talked a little bit about affirmative defenses. I should probably reorganize the framing of those slides, but so the next part of the answer, filling out the answer, is the affirmative defenses. Again, be over-inclusive rather than under-inclusive. Common affirmative defenses that apply in a lot of cases are habitability violations by the landlord. The landlord waived or canceled the notice to quit. For instance, landlord told the tenant oh yeah, it's fine that you haven't paid on the 5th, I'll accept it on the 7th, and then the landlord still files the lawsuit, even though retaliation. The landlord is filing the lawsuit because the tenant reported the unit to code enforcement or something like that. Illegal discrimination. I just want to be clear here. Under the law, not all discrimination is illegal, right? Discrimination just means treating people differently. You are allowed to treat friendly people different from unfriendly people, right? But you're not allowed to treat white people different from Black people, right? Certain types of treating people differently are prohibited. So if the tenant believes the landlord is treating them differently because of their race, because of the language they speak, because of their disability, because they have a Section 8 voucher, those are reasons to assert illegal discrimination in California. Other common affirmative defenses are just cause violations. For instance, if the tenant is protected by the TPA, the Tenant Protection Act, and the landlord doesn't state any cause on the notice, just says, you know, we're terminating, goodbye, that's a violation. That's a defective notice. CARES Act violation. I don't know how many of you heard about this during COVID, but the CARES Act, which was passed during COVID, requires federally subsidized properties to, in a notice to pay or quit, allow the tenant 30 days to quit, not 30 days to pay under most interpretations, 30 days to quit. But if the notice, so if it's a federally subsidized property, for instance, a LIHTC property, low income tax credit, or your tenant has a Section 8 voucher, then a notice to pay or quit must be a 3 days to pay / 30 days to quit. So failing to provide that 30 days is a big notice defect that you can assert in your answer. DV protections. If the tenant is being evicted because of being a victim of domestic violence or stalking or elder abuse, the tenant can assert in their defense, like, yes, this thing happened, but I am a victim of DV, and so I can't be evicted for that. Common example might be an abuser comes to the apartment complex, breaks a window, picks a fight with the neighbor. The landlord says, oh, you have a guest who you are responsible for, who broke a rule here. We're evicting you. The tenant would assert their right as a victim of domestic violence to not be evicted for, you know, they would say basically like, this person isn't my guest, you know, they're my abuser, so don't evict me. Rental assistance, third-party payment. To be clear, this defense is not landlord refused to accept rental assistance after the 3-day notice expires. This defense is tenant provided rental assistance within the 3-day notice period and the landlord refused to accept it. So that would be a violation. There is like a specific document requirement for that, but anyway. And then another common affirmative defense is reasonable accommodation request denied. Say a tenant gets their is on federal disability benefits. They get their disability benefits on the 6th of the month, and they say to the landlord, please reasonably accommodate the effects of my disability by making my rent due on the 6th, because that's when my check comes. And the landlord says no, and then evicts them when they pay on the 6th instead of the 1st. Failure to reasonably accommodate in a case like that is a clear defense to an eviction lawsuit. So yeah, these are, I went into maybe more detail than we needed to here, but these defenses are all super important resources for tenants. And again, always be over-inclusive rather than under-inclusive when you're filling out your answer. Next slide. All right, last bit of the answer. There's a little section for other statements. You can say if the tenant has already moved out, that's a defense to an eviction. So if you've moved out, if the tenant moved out, write down the day they moved out. If there are big habitability issues, you can write that down here too, as a way to say the landlord's demanding too much rent because this place isn't really worth it. Paragraph 5 is where the tenant tells the judge what they want. If they want attorney's fees, if they want the cost of filing their answer back, if they want the court to order the judge to make, if they want the court to order the landlord to make repairs within a certain time frame. Anything else they can think of that they think the judge might consider. I mean, you know, be realistic. And then last, a tenant The defendant must sign their answer in two places. There's the attestation section where they to say, like, did you or did you not use a UD assistant for compensation to help with this form? I'm going to be totally honest. I have no idea what a UD assistant is. I have never met one. I have never checked the yes box on that. There's like I think there's a legal definition of it somewhere. And then the second thing is the verification. The tenant signs to say, I swear under penalty of perjury that everything I've put here is true and correct as far as I know. And if you try to file an answer without both signatures, the clerk will reject it. So that's why we emphasize that. Next slide. All right, hypothetical. The landlord's complaint is demanding past due rent in the amount of $3,000. Can the defendant check box 2A, the general denial box, in this case? All right, got a good number of answers. I think we can end the poll. It's a fairly even split. I guess I should rephrase this question. The answer I was looking for is no. When the complaint demands more than $1,000, you're supposed to check the specific denials, not the general denials. But better to click general denial than to just panic and not fill out any of it. Yeah. Next slide. Where are we at? True or false? There is only one place on the answer where the defendant needs to sign. All right, got a good amount of participation. Most people got that right. The answer is false. Defendant needs to sign twice, 2 lines. Next slide. All right. The other part of our step 4 is filling out the fee waiver. So we've gone through the whole answer, and then there's a fee waiver. Low income persons may be eligible for a fee waiver. If you don't apply for a fee waiver, you have to pay about $200 just to file your answer. So definitely worth applying. The fee waiver form is just 2 pages. And if the court grants the request, the tenant will not have to pay filing fees, or can sometimes have their filing fee amount reduced. If the tenant / defendant is receiving government benefits that are need-based, almost all of those will automatically qualify them for a fee waiver. CalFresh, SSI, Medi-Cal, I think CalWorks is on there. There's a little list, so you just check which box applies to you, and then you say, yep, I promise, and then file it. If the tenant does not receive a need-based government benefit, they may still qualify. They just have to give a little more information about their budget and their income. Next slide. All right. You have completed your answer and fee waiver. Now you have to find a friend or somebody to mail the answer to the landlord and sign the proof of service form. The tenant has to find anybody who is not named in the lawsuit and is over 18 years old to serve a copy of this answer to the landlord. Service just means mail in this case. Case managers can do this. Yeah, Yeah. So all they have to do is they take a copy, they put it in an envelope, stamp it, mail it to the address at the top, named for the plaintiff in the summons. That part on the very bottom of the form on the summons where it says, plaintiff or plaintiff's attorney is here, and here's their contact information. That's where you mail it. And then once it's mailed, this person who mailed it will sign a form called proof of service for mailing. And then the tenant just files that form with the court. Yeah. Next slide. Poll question. Who can serve the answer on the plaintiff and fill out the proof of service form? A, the defendant's child who is under 18. B, the defendant themselves. C, the defendant's child who is over 18 and is named in the case. D, anyone else who is not named in the case and is over 18. All right, we got about half of people responding, and almost all of you got this right. It is D, anyone who is not named in the case and is over 18 years old. Next slide. Step 6, this is comparatively easy. File the answer and the fee waiver with the courthouse. The tenant must go to the courthouse during the clerk's open hours, ideally, and just wait in line and hand it to the clerk. The clerk stamps it. Tenant can ask for a copy if they want, and then it's filed. If the clerk sees that there's a defect, for instance, if the tenant wrote their name wrong / not consistent with the summons spelling, the clerk will say, oh, you have to fix that, and you fix it right then and there. It is possible to file your answer and fee waiver by putting it in the clerk's Dropbox, which is also at the courthouse, which is accessible until 5 p.m. But if there is a defect when you file in the Dropbox, like you spelled something wrong in one of the party names, the clerk will reject it, and it'll take you'll be risking a default judgment because the clerk might reject it, and it'll take some time for you to find out and then refile. And in that time, the landlord could potentially seek default. Currently in Santa Clara County, our clerk's hours are 8:30 a.m. to 3 p.m. Monday through Thursday, and then they close at noon on Friday, and then the Dropbox is available till 5 p.m. There is an electronic filing option, but it is not intuitive. It's not easy to explain. So it is much simpler to file in person unless you have an attorney assisting you. Next slide. All right, handing it off to Darlene.
Thank you, Anna. All right, so a lot goes into obviously filing the response and answer, and then step 7 is getting ready for trial. And so after an answer is filed, the client will receive a notice of their trial date in the mail. So the best advice I can give is to make sure, that if a client's in the middle of this process, is make sure they keep an eye on their mailbox, check their mail each and every day. If they're, general practice is their kids get the mail, or, a roommate gets the mail, really have, like an inbox on the kitchen counter or on top of the refrigerator is another option as far as, making sure you don't miss those important notices from the court. So again, there will be an envelope from Superior Court of California, Santa Clara County, and inside will be a notice of a trial date that will have the date and the time. In Santa Clara, trial dates are scheduled generally Wednesdays, Thursdays, and Fridays at the Superior Court downtown. And and then I know a lot of clients have the email notifications as to the mail that's coming in. This is also really key. One of the things we're seeing with a lot of the apartment complexes or the mailbox system, on site, we get so many cases where the mailboxes have been vandalized and are not currently in operation, and tenants are really having a hard time getting their mail. Sometimes our clients don't have a key to their mailbox and they can't afford to get a replacement key to their mailbox. So it's really important that they have a way of keeping track of their mail. If this is a concern for your clients, they can also call the court every couple of days to find out if a trial date's been set. But of course, you may have to sit on hold for a while to get connected with the clerk to get that information. But it's really key because it will get set very quickly. And again, the trial gets scheduled generally within 20 days, which is not a lot of time to prepare. Getting ready for trial, gathering evidence. If a client has evidence that they paid and were not credited for the alleged non-payment of rent, they can use this time to contact their bank. If they paid by money order or cashier's check, they have time to get those documents so they can say, hey, I paid this amount on this date, and here's proof from the bank that I did. But these things take time to get. So of course, using the time, critical to use that time to have those documents prepared. So that way, this information can be given on the trial date. Also, any witnesses that are willing to testify, let's say it's a matter involving, alleged criminal matter. And let's say, that the client was, in Southern California, the weekend of the alleged criminal activity that they're saying this person, participated in, and they have a witness. You want to make sure that they're available on the trial date and informed of the date and time of trial, so that way that information can be given. And again, making copies of all the important documents, bringing the 3 copies of each document, one for you, one for the judge, and one for opposing counsel. Bay Area Legal Aid, we have a getting ready, like a trial date preparation sheet. So our legal advice line will generally give that out to clients who call. If our office is not able to take on a case and provide representation in court, generally our legal advice line can provide, the trial date preparation sheet, just to know what to expect the day of trial. It can really alleviate a lot of the stress and anxiety that goes into preparing for a trial date, just to, really have an understanding of what happens on that day. First and foremost, again, with the notice, it'll say the date and time, and the trials generally are scheduled. It'll say 8:45 calendar on a particular date. Just a note on that. So parking downtown is difficult. It can be hard to find a meter that's available within, walking distance to the courthouse. It can take more time than you think because of traffic and finding parking. We do have the light rail that goes right in front of the courthouse. So that, that is a great way for, public transportation options. But you need to build in that time. The court doors open at 8:30, and then that's when the bailiff will start signing people in for their court appearance. And the notice from the court will say that the defendant, the client, is required to be in court. And this is even if they're represented by an attorney, they have to be there. And so they have to be able to sign in timely with the bailiff. If they show up late, and it doesn't matter why, the case could already be called and a default could already be entered. And that's, completely, something that we want to prevent happening. I know personally, I've been, stressed out. I'm there on time waiting to, meet a client, and, things happen, traffic happens, accidents happen. But unfortunately, the court will proceed with or without a client. So it's really critical that they get there on time and have a transportation plan for that day. Okay, next slide. Okay, so on trial date, and part of our trial day information sheet will talk about how a court operates the day of trial. And so the court will generally call cases one by one. They usually start with interpreter matters first, because the court interpreters have to go to other courtrooms for services. And so they'll call a case to see what the status is. Perhaps, something's been done prior to the trial date where the case has settled. Perhaps the parties have reached an agreement and there's already something that's written and signed, and it's just a matter of getting that filed with the court. So if that hasn't happened, the court will call the case, and the court will also have in the courtrooms some community resources. So the city of San Jose is generally there regarding the EDSP program for rental assistance. There's other community providers such as Sacred Heart that are present in court that day, and also mediators who are available to go out in the hallway with the parties and conduct a mediation session to see if a settlement can be reached. And so those are some resources that are available on the court day to see if a case can potentially settle. And then the court will recall a case, for a case status. So in terms of how to negotiate a settlement, some preparation should be done prior to the court date for that, to be able to, have a client look at their budget. Can I afford to stay in this unit? Do I have the ability to, pay off these arrears either myself or through rental assistance programs? And then what does ongoing rent look like for me moving forward? Or is this just, something that's, going to happen again in the future? Should I stay? And I need to figure out my living situation and have a plan of action, prior to showing up for court that day. Both tenants and landlords can offer, a negotiated settlement. Common settlements that we see include settlements like cash for keys, which is when they basically are saying, we're not going to go forward with the trial, and that saves the landlord the cost and both parties the time of going to trial. And they'll say, okay, I can't move out prior to the court date, but I agree I'll be moved out within 30 days, and they'll, hopefully be negotiated a waiver of arrears for that agreement to move out by a particular date. Sometimes, like I said, in the time before a case comes to trial, there might be some communication and exchange regarding what that looks like. And so the parties may be able to reach an agreement and have that all signed and in writing prior to the court date, which is always great. But if not, then the negotiations take place right there at the courtroom on that day, generally just right outside the courtroom in the hallway. And then, utilizing the assistance of mediators, parties might go from, one side of the hallway to another to negotiate with both sides, have private conversations, and try to reach a settlement. Most of the landlords will be represented by an attorney, much more than a tenant will be represented by an attorney. So if the landlord drafts a settlement agreement, either through their attorney or on their own, the important thing is to read it very carefully. The client should make sure they understand what each sentence means before signing and not feel rushed. Again, there's if language is an issue, there are interpreters that that clients can utilize for making sure they can understand what they're signing. If there's any uncertainty or confusion about what the landlord is offering, they shouldn't feel pressured to sign it. They can make a counter offer or they can proceed to trial. Generally, there are negotiations and settlement agreements that do offer clients some significant terms that will allow them to preserve their tenancy, and also some benefits like waiver of arrears. But a lot of those agreements also are accompanied by language which is very strict in terms of what happens if the parties, let's say they set up a payment agreement and then the tenant later misses a payment. The consequences are generally put into the stipulation as well. And it's important that a client understands them, because what could happen is what prevents a case from going to eviction now, if it could be very risky for them to sign something that they perhaps know that they're not going to be able to follow through with later, and then ultimately end up with an eviction judgment due to the language that's in the stipulation. So it's important to take the time, even with a very rushed process of the court warning, is to make sure they understand. And so, it's best to have, someone there that can help, explain the process to them, and utilizing the mediators that will go again from side to side. If the parties agree to meet with the mediator, that can be really helpful in order to communicate information in a neutral way. If the parties do not reach an agreement, then the case goes forward to trial. And again, down in bold, if a tenant enters into a settlement agreement but does not comply with its terms, the landlord may be able to, based on the stipulation and what's in writing, is they can get a default judgment against the tenant without a new court date, and then that would result in an eviction judgment and a money judgment against them, which is, definitely something that we don't want. And generally the language often includes just, really harsh language and not tenant friendly at all, in terms of like very little options to be able to fight that later, because they're saying, okay, this is the agreement you agreed to, and if you don't comply, if you don't pay your rent on time next month, or for a period of time, if you miss an arrears payment, we will go to the court and we will ask for a default judgment against you. Just a note before we go to the next slide, cases proceed to a trial. It could be a bench trial with a commissioner or a judge, or at the time that the parties file an answer, they can also request a demand for a jury trial. And that doesn't mean it has to go to a jury trial, but it protects your right timely to have a jury trial. And there can be advantages as far as, a jury trial versus a bench trial, in terms of, having a jury of peers versus having just, one court officer decide the case. Okay, next slide. I wanted to go over some definitions, just in terms of, on the day of court, there's, a lot of language, there's a lot of acronyms that happen. And so just wanted to go through some basic terms. First of all, a stay. When a client loses as trial, or there's a judgment, that the law does allow them to request a stay for up to 40 days from the date of judgment. And that means that the tenant can stay housed in their current unit, but they have to pay the daily rate with the court up front before the order is granted to allow the tenant to stay in their home for that 40-day period before they can do that lockout. It's important, if you are entering in a settlement agreement, that there's no waiver of that right. And, because you don't want to do anything that will prohibit your legal right to ask for that additional 40 days. I know in terms of, it can be difficult in terms of, you know, depending on the amount of the daily rate. A lot of clients can't afford to do 40 days. They might do some limited number of days based on what they can afford. And you know, I know based on the resources that are out there, you know, a lot of the assistance programs do not cover rental assistance for that 40-day period. But it is effective for keeping tenants housed so they can, pack their belongings and leave on better terms than losing, their property interest in things they have to leave behind because a lockout happens and they're not able to get, the additional benefit of the 40 days. And also the additional time to find new housing or services for housing. Another term is set aside if a person loses at trial. For instance, because they didn't get notice of the lawsuit, let's say they were not properly served. Unfortunately, there are process servers out there that file documents that are not true. And so we have seen sometimes that clients were out of town and they have proof that they were out of town, and then there's a proof of service on file saying that they were personally served at their unit on a particular date and time. And so a set aside motion might be able to be filed based on the circumstances of the case, or any other reasonable mistakes that might have happened that can set aside the judgment that was issued against them. A lot of evictions are judgments occur because of default judgments. And you would be surprised that, the number of cases where the client either misunderstood or really truly did not know that there was a case against them. Let's see. If the trial was regarding unpaid rent and state rental assistance funds were approved for all of that unpaid rent, there is a form UD 125 that can be filed with the court to request a relief from forfeiture. And then masking. Masking is a term that will come up, and it's a technical legal term that means the eviction case will not be searchable through public records. And so one of the benefits is that, the eviction cases are masked. The notices from the court will inform the parties of that. So if you go into the online system and you look up an eviction case that's pending, you won't be able to find your client's name. Unless there's been a judgment against them, then it will it will show up. But if a case remains masked, then it protects the client from, let's say another landlord looking in like, oh, does this person have evictions? Let's pull up their name on the record, see what we can find. The eviction cases won't be able to be there unless there's that judgment. And so they call that term masking. Okay, next slide. Okay, and just to recap, there are lots of resources in court on trial date. And so when a tenant goes to court, the court commissioner will be up front, and then in the jury box, there'll be individuals that are from different rental assistance agencies that are there in court, and also the mediators. So again, if you have a tenant who lives and resides in the city of San Jose, there could be rental assistance available to them through the Eviction Diversion Settlement Program. In terms of appearances in court, we were just talking about this yesterday. I know that they're there on Fridays. I believe that they've increased that as well. And so EDSP, I believe, is there additional days as well for the trial dates as well. If a landlord is open to accepting rental assistance, and a lot of them are, then, the parties can negotiate to continue the case for 1 week. And so that way they have the ability to talk to EDSP. These are important funds that can, if a tenant is qualified, can provide a great deal of rental assistance to enable a tenant to maintain their tenancy and reach an agreement. So if for some reason the representative is not there, a tenant should definitely exercise, their ability to see if they get a continuance in order to do that. Again, Sacred Heart Community Services is also a great community partner that's there in court in regards to rental assistance, and can meet with parties out in the hallway to see if there's like a pre-screening. These things also take additional time, and the representatives that we've worked with have always been really great at communicating like the length of time that it may take to process their case to see if they qualify or not. There's a lot of factors involved. There's a lot of paperwork involved, budgets and things like that. And then there's also Project Sentinel is a great community partner that will provide the mediators on court day. And so they're there at court as well. They can do a lot of those pre-screening right there in court, in the hallways outside court, to see if clients are eligible for rental assistance. And so things that a client can bring to get that process started and be able to get a lot done that day is, copies of their IDs, pay stubs, bank statements, because there's going to be some budget forms and some things to sign. And Anna has things to add, so I'm going to open it up to her as well.
Sorry, Darlene, I just wanted to say, I changed the slide to say EDSP is no longer in court every day, because earlier this year that was true. But I checked with them yesterday and they are back in court on all of the eviction trial days. So for now, that's all.
Thank you, Anna. Yeah, it's great to have them there every day. I know I was in court on a case and it was on a Thursday and they weren't there during that time period. And so we all had to come back the next day. And, and so aside from, the landlord's attorney who said, well, then I'm going to ask for more attorney's fees because I have to come back. And then, of course, our clients took off time and had the cost and time of transportation to downtown to appear in court. So it's really great to be able to get those resources available all on the same day, so that way things can be accomplished. And so really, protecting the time and our clients, like if they're taking time off from work to come down to the courthouse and resolve their case, these programs are so substantial and really resolve so many cases. It's so important that they're able to, meet with the clients. So, and we're very thankful for those programs. Okay, next slide. Okay, so then ideally and most frequently, cases do resolve by stipulation, especially non-payment cases. There's, again, especially with the financial assistance programs that are out there to support tenants, if it's a non-payment case, the landlords have filed this because there's a rental arrears and they really want to collect on those arrears. And so, so more often than not, the parties do reach some sort of settlement agreement in regards to either a lump sum payment towards what is owed or a portion towards what's owed with some sort of payment plan for future arrears. There are some times where rental assistance is not available. The client is not eligible, particularly if they cannot access services that will provide for ongoing rental help moving forward, and they're not able to sustain their current rent. And so, so it may leave a tenant in a non-payment case or a case that's not able to be settled because, let's say for a nuisance case where the landlord is not willing to negotiate or come up with any terms to have the client stay, then a case will proceed to trial. If it's a bench trial, the parties, generally, it could be a very quick process, 30 minutes, and then the judge will decide for either the tenant or the landlord. If a judge finds for a tenant, typically the tenant must pay all the rent that's owing, and then their tenancy will continue as if nothing happened. And this time period is very short, it's generally 5 days. So if they'll say, okay, we're going to find in your favor based on the defenses you raised in your answer. But there is still a finding that you owe this rent, and you have a very little time to be able to pay that forward. If the judge finds for the landlord, the judge will issue a writ of execution, and that is the legal document that the landlord takes to the sheriff. The sheriff will go to the tenant's door, posting a notice with the date and time and saying they have generally 5 days until their locks are changed. We're seeing, due to volume, is that it sometimes is taking the sheriff's department longer. So they may come back at a time later than that. And in this time frame, that's where the tenant can file a request with the court for a stay of execution. But again, that's up to 40 days, but the tenant will have to pay the court directly upfront for the extra days. When the sheriff returns on the date of the lockout, the sheriff can come and essentially, what we hear is they say, gather a few things, and then we are locking the doors, and then locks are changed to the door, and the tenant leaves the property. And certainly, this most difficult of situations, and, all of the resources that, are available to our clients, we really want to utilize to prevent that from happening. And certainly, the stress and trauma that type of eviction, and, we don't want our clients to experience that. So that is why we're all committed to working together to prevent that kind of result. Okay, next slide. Okay, again, some tips and tricks for dealing with the eviction process. As Anna stated earlier, it's so important to spell each name exactly as it appears on the summons and complaint. And even if, and this happens a lot, it's misspelled. And so the caption will say, a plaintiff name and then a defendant name. What we see a lot is also, if I was using my name, for example, it could say Darlene Williamson, AKA Darlene A. Williamson. And if I file my answer and I just put Darlene Williamson, the clerk's going to reject it. Or if they spell my name Darlene with D-A-R-L-E-E-N and I spell it properly, which I should feel justified to do, my answer is going to get rejected because I did not mirror the caption exactly as it is on the summons and complaint. And so that's an important thing, because you, especially with a tight time frame, you don't want a document to get rejected, and then end up not having time to get that answer in properly and timely. So that is just a note that's important too. That comes up a lot, more often than it should. In terms of filing an answer, what happens when a client misses the 10-day deadline? Our advice would be that they should go ahead and file the answer as soon as they possibly can. We know that there are certain landlord attorneys out there, like I said, who file things like clockwork. And so their request for default will be ready to go and filed after that 10-day deadline. But sometimes that doesn't happen. And so if the client can get their answer in prior to the default being requested, then the case gets set for trial. They have more time to be able to, one, obviously present a defense and have an answer with their defenses raised, and prevent a default judgment from happening. But best practice is to make sure everything is filed within the 10-day deadline. And also just noting, in Anna's earlier slide regarding the dates or the times that the courthouse is available for filing. to not miss those, particularly on Fridays because they close at noon and the doors will be closed. There's a drop box, but it's, it's best to be able to walk away with those file stamped documents in hand, knowing that you filed on time. And then what happens when a tenant, sometimes they get a sheriff's lockout on their door. They don't know that there was a trial. They don't know what happened at trial. What they can do is they can go down to Superior Court records and they can go to the clerk's window and get a copy of any documents regarding the case that's in their file. And so they'll need the case number and they'll need to have the address of the property that's in the summons and complaint. Because again, eviction cases are masked, and so you need to have that identifying information for the clerk to be able to assist. And it'll show a copy of everything that's in the file. Everything should be in there from all of the notices that the Superior Court sent out on the case, the summons and complaint, any other accompanying documents. And there'll be a list of what's called a register of actions that will just show everything that's been filed in the case. And so definitely utilize the clerk's office to be informed that, there's a case and that there's, what the status is, particularly, especially if there's a default judgment, because if there is a default judgment, there are some legal steps that can be taken quickly in order to resolve potentially a default judgment. And so it's just important to be informed and to do that follow-up on the case. Okay, next slide. If my colleagues have any other tips and tricks that they want to share, I'll open the floor to them as well. But I just want to say thank you to everyone for attending these sessions these past 3 weeks, and open the floor to any questions as time permits.
I think we did have one question that that Sadika sent out beforehand that I don't think Tanya emailed this. People want to know, how can you remove an eviction from a credit check? That's really a consumer law question. And I don't know much about consumer law. But I do want to say you can remove, it is possible in some circumstances to either remove or seal an eviction judgment in limited circumstances after the fact. In a case where a tenant gets evicted and only learns that there was a court judgment afterwards, the tenant, they were incarcerated when the notices went out, or they were in the hospital or something, right? And they just missed it and they came back and were locked out, and they sort of moved on, but they want their record cleared. They can file a motion to set aside the judgment for a service error, right? Or because there was this other circumstance that was preventing them from accessing their notices in a normal way. And often, once the tenant is already out and in another place, the landlord won't oppose very intensely. So a judge may grant a motion to set aside, which would take it off the record, off the court record. However, as far as I know, getting a judgment set aside is not the same as notifying creditors or credit agencies that something they have been reporting is no longer valid. So there's some other consumer law process that you would have to go through to notify the credit agencies that there's been a change, I think. Also, in some cases, this is, I would say, not super common. A tenant could seek a motion to seal the record or mask the record. It would have to be compelling circumstances. The tenant would have to say to the judge, this is going to hurt me more than other people, in a way that I think you should basically overrule the standard law about having eviction records public in my case. So maybe somebody is a victim of domestic violence and it makes them very worried to have any public records about where they have recently lived at all. They could file a motion to seal. And again, in a case where the tenant has already moved out and is just trying to clean up the record, a landlord or a landlord's lawyer is unlikely to oppose this with a lot of energy, because their primary issue is getting the unit back and being able to re-rent, and that's already been resolved. So those are two options. But again, that doesn't precise that those things can help, and I think often are useful for people to pursue, but that's not exactly the same as getting the credit reporting agencies to change their records. Sorry, we have a lot of people who are asking questions while I was talking. Someone had their hand up. I thought maybe not. Lauren asked in the chat, can we talk more about how masking works? In general, right, court records are public records. Anybody can go into the court and say, I want a copy of these filings in these cases. Right? It's an important feature of our legal system that court processes are public and accessible to the public. Masking is where, either through agreement or court order or statute, the court says, okay, we will not make these documents publicly searchable in our record database. Masking in eviction cases usually allows for anybody who knows the names of both parties and the actual exact address at issue to get a copy of any of the filings, right? But that doesn't help credit agencies, right? Because they don't necessarily know the exact address. They don't know the landlord's legal name, right? So it makes it harder for them to get at that information. It protects them from, it protects tenants from having cases that resolved through settlement or without a judgment against them being reported to credit agencies, or just searchable by people who by other landlords. And it's just done by the court's clerks / IT department. They just change the status of these records within their files. Does Darlene or Allison, do either of you have more information about that?
I think you covered most of it. Again, if a case goes to default judgment, then one of the things in terms of clients addressing that default judgment is to see if they can resolve it either through a set aside, especially if they weren't served, and see if they can, get that default judgment set aside, and then, or potentially I haven't seen this in terms of a default judgment set aside, but in terms of reaching a settlement on trial day, I have had clients that weren't able to do any sort of payback of arrears or stay in their unit, and ultimately moved and did reach a written agreement that there would be a judgment. However, the opposing counsel agreed that it could remain masked. So it may be even something that can be added as a condition on the negotiated settlement in writing. And so that way, if the landlord doesn't keep it masked, that there's documentation in writing, because we always say if it's not in writing, it didn't happen. And be able to have their case remain masked, so that way they have at least the benefit of moving forward to find a new place without having that blemish on their background checks.
Lisa asked in the chat, does an eviction automatically mean a tenant would lose their housing voucher? No, not automatically. A tenant you can lose a Section 8 voucher for having an eviction, for being evicted. But anytime a voucher, the housing authority plans to terminate a voucher subsidy, they'll issue a notice about like intent to terminate subsidy. And on that, there is like a notice that's a statement that'll say you have like, I think usually 10 days to contest or appeal this decision, to request an informal hearing. You know, depending on the reason for the eviction, but as long as the tenant requests the informal hearing timely, I'd say, you know, you have pretty good odds of being able to preserve and, you know, appear at the hearing and make your arguments, pretty good odds of being able to preserve your voucher. I mean,
Yeah,
not if it's like physical violence, that would be much harder. Like, and there are some things, some eviction bases where the housing authority is required to terminate a tenancy. I mean, to
Okay.
terminate a subsidy, but
Gotcha.
it's pretty narrow. Sorry,
Okay.
Lisa, I didn't mean to talk over you.
Oh, I also didn't mean to talk over you, but yeah, I've heard of people who, mostly because of rent issues and being able to make the rent, where they may necessarily be evicted from one apartment but are more able to afford a different apartment, so they don't technically lose their voucher, they just lose that apartment because obviously it was out of their range or certain circumstances like that. I have heard other cases of things happening and lease violations where people still don't lose their voucher, and you know, I'm glad for that, you know, as long as everybody's safe. But you know, it lessens the people that are going to end up homeless. So I mean, I think it's important that even through eviction, that the vouchers, you know, able to be resumed in a different atmosphere.
Yeah, no, it's absolutely an important protection to exercise. And yeah, at least the Santa Clara County Housing Authority, I think, we've gotten good results on preserving vouchers even after evictions. Again, like you said, depending on the basis for the eviction or the conduct of the tenant.
Well, we have about 9 more minutes if anyone has questions. But in the meantime, I actually am gonna put in the chat a feedback survey form that we would like you all to fill out about today's training session. And if no one has questions, really want to thank our trainers, presenters for today from Bay Area Legal Aid, Sarah, Allison, Darlene, Anna, providing such an informational three-part training series. Very thankful for having you all present today. And if anyone has questions about today's training or any of the trainings that we just had over this 3 weeks, please feel free to email Santa Clara Homebase dot oh, sorry, I think I messed up the whole. I'm gonna actually just put it in the chat. There you go. Santa Clara CoC at homebaseccc.org. And we can follow up with any questions you may have. And also, the slides will be sent out via email, and then the recordings, once posted on the CoC website,